Hi, my name is Benjamin Hart. I'm Managing Director of Integrity Legal here in Bangkok, Thailand. This video is to briefly discuss Section 214B of the Immigration and Nationality Act, how it pertains to visa denials at the U.S. Embassy in Bangkok or at any U.S. Embassy around the globe for that matter. 214B is kind of a thorn in the side to anyone who has ever attempted to get a foreign national a tourist visa to the United States of America. By tourist visa, I mean either a B1, B2, or B1, B2, or for that matter, any other type of non-immigrant visa, specific non-immigrant visa. 214B basically creates, in the mind of a consular officer adjudicating a non-immigrant visa matter, a sort of strong ties, weak ties analysis. Basically, the person who is interviewing for a visa must show strong ties to either their home country, here in Bangkok it's mostly Thailand, or to a third country that's not the United States. So if you have a Thai national that, say, has dual nationality with Canada, they could have strong ties to Canada as opposed to Thailand, and that would still fit the analysis. In any case, that individual who's applying for that visa must show strong ties to either their home country or another country abroad, and they must show weak ties to the United States of America. This is a simultaneous thing. They have to show strong ties, weak ties, strong ties, weak ties analysis. A consular officer making this determination, if they determine that that individual's ties to the foreign countries are too weak, or determine that the ties to the United States are too strong, or any combination thereof, they can deny that application, and it's not unheard of that such denials occur. With respect to 214B, a quick side note regarding a notion under U.S. law regarding consular absolutism. There's a very old case. It went to the United States Supreme Court probably within a few decades of the country being founded, or at least 1789 with our current Constitution, where a plaintiff brought a case to the court and basically said he felt that a visa denied abroad was denied unfairly. The courts basically created a doctrine called consular absolutism at that time, where they basically said, look, we're not going to get into the business of peering over the shoulder of every consular officer operating abroad. We're basically going to say that that's the person with the boots on the ground, they're making that determination, and we're not going to do anything to overcome it. So essentially what consular absolutism means is exactly what the term implies. The consular officer has absolute power with respect to the adjudication of a visa application. In essence, a consular officer could simply not, quote-unquote, like the look of someone and deny a visa based on that. In my experience, that's not how capricious the system operates. They don't, consular officers in my experience don't tend to make denials based on those matters, based on those types of circumstances. What they tend to make denials on is exactly what 214B was created for, which is they basically look at the overall situation. They say, on balance, this person shows weak ties to their home country and stronger ties to the United States, and therefore we think that that person could possibly be a risk of showing up in the U.S. on a non-immigrant visa and simply staying there. And for that reason, they deny that visa application. Another thing to note with respect to 214B is also a notion that can occur with U.S. Customs and Border Protection, which is what is called a intending immigrant without proper documentation. This sort of finding will occur from U.S. Customs and Border Protection, and it's very similar to a 214B finding abroad. What they're basically finding is that, oh, this person has a validly issued tourist visa, they're coming to the United States, but all evidence points to the fact that this person may be using this tourist visa in order to circumvent the immigrant visa system and come to the U.S. and thereby use that tourist visa status to essentially covertly immigrate to the USA. In situations where Customs and Border Protection makes that finding, that individual will probably be turned around from the United States. It's possible that that person can be put in what's called expedited removal proceedings, which is essentially, it's an expedited deportation, and that individual could be barred from returning to the United States for as much as 5 years. In my experience, such individuals who enter on a tourist visa and are found to be entering with immigrant intent such individuals are usually allowed to withdraw their application for entry and return to their home country. In most cases I've dealt with, that's Thailand. Those individuals, if they voluntarily depart the United States, there is no explicit immigration demerit that's gained from that. That individual can later apply for another visa without any inadmissibility issues or any specific inadmissibility issues, generally. It should be noted further with respect to things like consular absolutism and U.S. Customs and Border Protection, one further thing: notwithstanding the issuance of a valid visa, the United States Customs and Border Patrol officers are allowed to simply turn someone away. Again, they have very broad powers with respect to those entering the United States. Until such time as a person with a valid U.S. visa has entered the United States and been cleared through U.S. Customs and Border Protection, that individual is not yet under all of the protections that the United States Constitution provides as far as legalities. Those individuals can be turned away from the United States using basically the plenary powers of both U.S. Customs and Border Protection, as well as denial at a U.S. Embassy abroad using powers under 214B, specifically for non-immigrant visas. A final thought: 214B is very different from denials of immigrant and non-immigrant visas with immigrant intent pursuant to 221G. 221G denials tend to be made for lack of documentation, and once documentation requests are fulfilled, 221G's refusals are generally overcome and visas are issued. If you're interested in information about a 221G denial, there's another video on this channel where you can check out what a 221G is and issues surrounding the 221G. That being said, a final note regarding 214B: if an individual is denied pursuant to 214B and then later attempts an immigrant visa or a non-immigrant visa like a K-1 fiancé visa, which can have dual intent, meaning that non-immigrant visa holder can actually enter the United States with the intention to remain there as an immigrant, the 214B finding does not preclude a later petition and application for, say, a fiancé visa or an immigrant visa based on a spousal relationship. Thank you.